The situation was that the property is an RDP. So now the title deeds haven't been given, right? And now we're on the 5th year, and now it was a property owned by our parent. So our parent has passed on, but the title deed hasn't been issued. So now because I wasn't around, Neo was living in that property and saw fit that he should sell the property. So now Faith came through and bought the property from Neo. She gave him the cash, and then they just wrote, we are buying this property. So what happens in that situation when I come back and say that, yeah, but it's also my parents' house?
I think importantly to note, one, is that RDP houses, when there's no title deed, you can't sell it. So there is no sale there. Because of the fact that once the title deed is issued, it's issued either to the deceased parents, or it's going to be issued to the people that are supposed to be the beneficiaries of the deceased parents. So what the department does of human settlement is that when the people were given the property as beneficiaries in terms of their own criteria, as the department passes on, now they call upon the children of those parents to find out if they qualify as beneficiaries in replacement of the deceased parents. Then if they qualify, then what happens is the department now won't issue a title deed in the name of the deceased parents. They will issue the title deed in the names of these children who are beneficiaries, because they qualify according to their criteria. Now, if it happens that you now decides to sell the property, then there is no sale, because that is a reversible sale. Because you didn't have a right, one, to sell because you don't own. Remember, even if, because what happens with the municipality properties is that when they build RDP houses, they build them for you to occupy. You get what we call an occupation of the property. Remember, there are two things. There's occupation, there's possession. So possession is when you're taking responsibility. But then occupation is when you're occupying something that doesn't belong to you. So there's no title deed in place, then it means that that property doesn't belong to anyone in the family except the department. So that is why you will find that in some instances, the department will rather take the property back to them until you guys sort out your issues.
So Faith has to move up.
Unfortunately, Faith has lost. Because Faith now, the only thing that is left for Faith is for Faith to claim from Neo the money that he gave to Neo. That is why when I was mentioning capacity, that the person has the capacity to sell. So if you don't have the capacity to sell and you don't have ownership, then that's a reversible sale.
Great. So, so remember, one of our clients was in a similar situation, but it wasn't an RDP. It was a normal house whereby the other people didn't know about that sale. So was there a possibility, or have you seen a situation whereby the house was transferred from myself to Faith, however now labor wasn't informed? Have you ever seen of such, or it usually gets stopped?
You know what, it happens because it mostly happens when the party that is labor is not mentioned in the title deed. So meaning the title deed maybe only mentions the deceased parents, and then you guys are not there. So a person does, I had a situation where someone bought the property from an estate, and yet the person who sold the property is not even the one appointed as the executor. So the beautiful part is that if there is no authority, whether there is no resolution for a company who sells the property, or no resolution for a trust who sells the property, or no authority for a person who sells the deceased property, then that is a reversible sale. So you as a buyer, it's your responsibility and duty to ensure that whoever sells you the property is the owner of that property. Or if he's not the owner, he's got the necessary authority to sell the property. Other than that, it's a reversible sale. You are the one who will be left with a claim to chase after this person.
That's deep. That's tough. Spec, I had one question, right? Especially as a property investor, we normally buy properties that have tenants in it, right? What would be the things that we should request from the owner before we buy the property? especially looking at it from a business perspective, because sometimes we do go to the property, we see people inside, but we don't know if these people are tenants or if they do pay. So from your perspective, what would you think would be the things that we need to ask from the owner in order for us to say that, yes, it makes business sense for us to live?
I think importantly is what I mentioned earlier, the offer. When I was asking who's supposed to give who the offer, I meant that you, as the buyer, are giving the seller an offer to purchase this property. Now, when you give an offer, you've got an intention around your offer, right? So your intention then is whether you want to buy this property for rental purposes or you want to buy this property for residential purposes. So in your intention then, you need to know which sort of questions to ask. Residing, it's different from renting. So if you want to buy the property for renting purposes, then it means that even if there's a tenant, maybe it might make sense to keep the tenant or it might not make sense, but you need to know. So therefore it means that when there's a tenant, the questions that you need to ask is, this tenant is here, he's got a lease, you need to see the lease. You need to see the terms of the lease. So the terms of the lease, do they mean that you have to keep this tenant until the lease expires? Remember, there's what we call Hilgard 4. That principle says that the tenant has got more rights than you as the new owner. Because once you come in there and then you did not ask for a vacant registration of this property at the time when you're giving an offer, it means you're inheriting the tenant, right? Then in inheriting this tenant, therefore important to have a lease agreement in place, whereby you would see the terms of the lease, one, and then number two, you want to know when you want to know firstly is the terms of the lease, and then secondly the duration. That's the word I'm looking for. Then you want to see the duration of this lease, so that even if you inherit, you're not inheriting something of someone who is going to be here for more than 6 months. So meaning you're going to have to deal with this person with the same lease, with the same terms for a period of 6 months, because you can't come in as a new owner and change the terms until the lease expires. So importantly, you need to see the lease agreement so you can know from the lease how much is this person paying, how long this person have been here, and then also the duration of this lease. When is this lease expiring? So you can know, you can then come and bring your own terms. So meaning if the lease is going to expire in 6 months, you can only bring your own new terms after the 6 months period. So that's what is important. And also you can ask the seller about the behavior. I know, Guti, maybe you won't get enough information from the seller in terms of whether this person is a good paying tenant. But sometimes, depending again on the type of the property, you can see that you can find that the seller is able to give you some form of history on the behavior of the tenant in terms of rental payments.
Last one from my side, SP, is that you mentioned something when it comes to generational wealth. We're always thinking about money, right? Making money and accumulating assets. Now, with the conversations that we're constantly having, then you come through from the asset protection side. Now, I'm so happy that you spoke about the importance of having a will and a trust, because a lot of people are of the mindset that I just need a will or I just need a trust, whereas they can actually coexist and protect your asset as a whole.
Yeah, true. I think what we need to understand is that there are certain assets that you wouldn't want them to be owned by your trust. So you need to deal with them. So we don't want a situation where there are 3 cars here and we don't know how to deal with the 3 cars. So there must be a will that gives us a direction, because the will is there to give whoever is appointed as the executor a direction on how to deal with the assets. So if these assets are not under the trust, there must be a certain document. That is why I'm saying with me, I do have a trust, and my trust is the one that owns everything. And then my will just says that I'm leaving everything, whether that thing is under the trust or is not under the trust, it goes there. So importantly is that there must be some form of direction on how to deal with the asset. We can't leave a certain asset hanging and then certain assets under the trust.
I think the last one from my side, Mrs. P. It's also with regards to the trust. would it be advisable for us to leave, when you have like your life covers and your life insurance, is it advisable to leave it in the trust or to just give it to the beneficiaries directly?
Okay. When we create a trust, we're creating a trust fund. So therefore it means that whatever it is that you would want to do for this trust, there is no limit. You can take life covers, and instead of having these life covers, because remember, life cover has got a lump sum that will be paid to whoever is appointed as the beneficiary in the life cover, then it means that if you are saying that I don't want this money to go to my kids, remember kids, now if you watched I Blew It on TV, then you will realize that you don't want to give your kids anything in their hands because money has power. Then it means that you can have your life cover divert everything to your trust, because that trust says you are creating a trust fund for the benefit of the same people, which is your children.